We are talking tonight with Tulsa family law attorneys, or Tulsa fathers' rights attorneys, Keith J. Flinn and Brian Jackson of dads.law. Want to continue on with kind of one of the topics we just touched on. And it's something that I think that a lot of times gets overlooked in a dad building his case in court. And that's the discovery aspect of things, getting that information. So I want to pass it off to you guys. Can you talk about some of the tools that can be pretty cost effective, or even pro se litigants can utilize to gather information from the other party?
I want to start off by saying that I do the game a little bit different than most lawyers. And the way that I play the game is I throw out a deposition and I will investigate every avenue that they may be creating or storing evidence, and create the story from the start before I submit written discovery. And then I'm able to go to a judge later and say, well, they didn't give me this. Maybe they deleted it. They didn't give me this. Maybe they deleted it. They didn't do this. You know, they told me this 6 months ago. Now they're telling us this. And so that's a higher end game, though. So if we're talking about discovery,
can you explain deposition to our viewers here, exactly what goes into that and how it works?
A deposition allows me to bring her into my office for a period of 3 to 6 hours and basically ask her as many questions as I want to. And generally speaking, the goal is to, one, create her narrative in a transcript that's transcribed by a court reporter, and then to allow me to figure out exactly what I want her to produce, what I want her to admit, and what I want her to provide me in list form in interrogatories.
Okay, so we get the deposition. That's kind of that's the biggest weapon in the toolbox, because you just get to have a conversation, like you said, in your office, on the record, under oath, for 3, 4, 5, 6 hours, where you can just get any and all questions answered. There's pretty limited objections if they have an attorney. You really get pretty much any information you can ask for during that time period.
In Oklahoma, they're only allowed to object to the form, and the client has to answer my question.
Yeah, so essentially they're just objecting for procedural purposes, essentially.
For maybe using it in the future if they want to dispute the fact that I'm impeaching them based on some question that I've asked. And when I say impeaching them, I mean basically making them look bad in court, making them look uncredible.
Basically, impeachment is you're looking for situations where their story's inconsistent.
Precisely.
You're catching them in a lie.
Exactly.
So now so deposition. In all cases, they would probably benefit from a deposition right away. Like you said, it's kind of a higher end game. It can be an expensive upfront cost on top of having to pay for all the filing fees and everything else. But if it's possible, that's something you want to do right away to pin them to the story. Now, you get that done, or let's just say you just financially it doesn't work where you can do that. And we move on to written interrogatories or written discovery. Can you talk a little bit about that and how dads can utilize that to gain that information?
It depends on your stated objectives and your goals, frankly, how you target written discovery, because you only get so many bites at the apple in written discovery. Now, that's not entirely true, because you can always ask the court to give you more opportunity. But in reality, usually you only get so many questions to ask and so many interrogatories.
How many is it in Oklahoma?
For interrogatories, production, or admission?
Interrogatories.
Interrogatories, you get 30.
Okay, so California, you get 35, and then you have to go in front of the judge.
So when I say discrete subparts, I mean that generally speaking, when we advise clients when we're defending discovery, a lot of times these lawyers will throw out a whole bunch, and you're not really required to answer all of it. And you're allowed to object if they exceed 30. When I say a discrete subpart, I mean, in each individual piece of the list that they're asking for is a discrete subpart.
Basically, if they're putting, ask the question A, B, C, D, E, each of those can be counted as a question.
1, 2, 3, 4, 5. Exactly. And
Yeah.
so you may see 30 interrogatories. In reality, it might be 90.
And California has something really cool. It's FL 145, which is actually, California is pretty exclusively a form-based practice when it comes to family law. You submit forms, and then you can submit declarations, briefs on the back end of these forms. And in the state of California, we actually have, and there's really no excuse for a dad not to utilize this, but we have a form that is the form interrogatories that don't count against your 35. So we have a form you can send to the other party, and it's got 20 questions on it that they have to answer, and those are just freebies.
We've got production like that locally. We've got what is called a DR5 production, and they're required to produce certain materials to you, but it's not quite like that as far as interrogatories.
It doesn't get very detailed, but it's something. It forces them to put something on the record. And a lot of times you can use that form, and then you can attach customized interrogatories, requests for production, requests to admit on the back end of that. So we'll transition. I'll let you take a crack at this one, Brian. So we have the interrogatories where you just get to ask questions and they have to give you a written response. So we have other pieces of written discovery, most notably the request to produce and the request to admit. Can you tell our viewers a little bit about those and what the differences are between them?
Yeah, requests for admissions are more or less what they say they are, which is the request is to admit or deny a certain factual statement. So, for example, if you have like a domestic violence case, you might ask the person like, admit that so and so never actually put their hands on you, just as for instance.
Mm-hmm.
And they're required to either admit it, or if they deny it, then if you prove it up later, there can actually be a monetary sanction involved for them denying it when it was true. Request for production can be request to produce like documentary evidence. You can ask for things like text messages, social media, audio recordings, video recordings, photographs, computer records. It's pretty broad, and under Oklahoma law, it's not only just what's relevant, but also what could tend to lead to relevant evidence. So you have pretty broad discretion to ask for things, and as long as it's not like unduly burdensome, like give me every scrap of paper you ever wrote anything down on, for example, you have pretty broad discretion to ask for them to produce whatever you want, and you can get it.
I want to add to the request for admission, guys. If you're doing this on your own, okay, don't ask her to admit some conclusion that you can ask the judge to make on his own. Ask them to admit components or criteria or some kind of element that you can actually then say, well, they admitted this, they admitted that, they admitted that. Now you can make the conclusion that X is thing. Because usually they're not going to admit your broad scale conclusion. But you guys know your cases way better than we do. I mean, Mark, you agree, right?
Client owns the facts. It's our job to build the strategy.
Exactly. So you're asking them to admit certain behavioral traits or instances, etc., which you can be like this, this, and this. Now, judge, you make the conclusion this. And that'll make your case easier in front of court because she's admitted this, this, and this. And if she doesn't, when she goes in front of the court, you can be like, hey, remember that? You already said this.
Go look at the elements. Go look at your state laws in terms of what needs to be proved up. Like you said, you're not going to get them to agree to some broad sweeping statement that sunshine and rainbows, you're the greatest dad on the planet. But you can get them to agree to small elements or even halfway agree to an element, and it's improving your case. If you can say, hey, she kind of agreed to this, like that element, then it's kind of taking it out of the judge's hand. It's like she's already said that. So be microscopic and you got to know your state laws, and you got to know what's actually got to be proved up in court and be strategic with it.
Couldn't agree more. And those admissions are really useful for that.
Yeah.
Yeah, definitely.